can I welcome the first of two panels we're having this morning on the state of electoral law, which is the subject of our current inquiry. And our first panel is representing the Law Commission for England and Wales. And could I ask you to introduce yourselves for the record, please?
Yes, I'm Nicholas Paynes. I am the Law Commissioner with internal responsibility for this project in the Law Commission here in London. Henry Wahes was the project leader working on the project for many years. He was promoted last year to manage all of the public law projects, but he retains an encyclopedic knowledge of electoral law and will, I hope, correct me if I get anything wrong.
Very good. Well, thank you very much. And can I publicly thank you for the informal briefing you gave the committee with your colleagues last month, which has been very valuable, but enables us to concentrate today on the key questions that we want to surface in public so that we can use your answers in evidence to our inquiry. Can I ask you to give as short and concise answers as you can, and we will reciprocate by trying to ask sensible and short questions. And can I ask to start with, how urgent is the need to update and consolidate electoral law?
Well,
by all means, if you want to make some kind of introduction about your work, now is the moment to do it.
Yes, well, just for the record, sir, people will know that the Law Commission is a statutory body set up by Act of Parliament with the task of reviewing the law of England and Wales and making proposals for its systematic development and reform, in particular its simplification and modernisation. And our method of operation is to conduct reform projects in various areas of the law. They vary in size and length. This has been a major one. We're conducting it in tandem with the Scottish and Northern Irish Law Commissions. And of course we published an interim report in February 2016.
So how urgent is the need to update and consolidate the existing law?
Well, we think it is urgent, and we said so in our report. It's not that it's impossible to conduct an election under the current legislation, but I've seen the written evidence that the Electoral Commission and Association of Electoral Administrators in particular have given you about the problems that their members, the members of the AEA currently face. We look at this issue from the stance of a law reform agency and on the basis of our assessment of the quality of the present law, which we think suffers from two main problems, one being antiquated and the other being, as we've called it, fragmented, spread around too many different pieces of legislation. I can develop that further if you wish.
So what do you think the significant risks are arising from the present state of the law?
There is a risk of error in the application of the law simply because it is confusingly presented. There have been some well-known instances of quite egregious error, and I mentioned a couple of them when I spoke to the committee last time. Well, such as because of our habit of creating a new set of legislation every time a new elected body is created, the wheel has to be reinvented, and sometimes bits of, changing my metaphor, bits of the mechanics get left off. There was an egregious instance of this when the Police and Crime Commissioner electoral legislation was written, and they forgot to include provision for Welsh language ballot papers and other materials, which are standard in elections in England and Wales, and that oversight had to be remedied at the 11th hour to avoid obvious embarrassment. Another embarrassment was when it was appreciated 2 or 3 years ago now that people had been miscalculating the deadline for getting onto the register in advance of an election and being entitled to vote at it. The calculation was unnecessarily complicated because you had to add 2 periods of time together drawn from different pieces of legislation. A mistake had been made by everybody for years, and the day regarded as 1 day later than it really is according to the law. That means that a lot of people will have voted in elections who weren't strictly entitled to, and think how much worse it would have been had the mistake gone the other way and people being wrongly prevented from voting at an election. Another one was when Council's opinion was taken 2 or 3 years ago again. Leading council advised that, contrary to what everybody had believed, it was not lawful to submit your nomination paper in a local government election by post. So no doubt there have been a lot of local government councillors who did so, and strictly speaking should never have been elected because they didn't validly file their nomination paper. That doesn't matter in the sense that no harm's been done, but the law simply shouldn't be in doubt in the way it currently is.
But I mean, I would describe these as mainly technical risks rather than real political risks.
Yes.
If I may add to what Nick has said, there are a number of technical risks. They've added up year after year. What we've got from consultation, from ongoing engagement with stakeholders, is that, to add another metaphor, the system is full of sticking plasters. Everybody's risk appetite, if you like, is getting lower and lower. We've managed to bolt on a number of new provisions to the 1983 Act, mainly the Representation of the People Act 1983. The main view isn't that things have gone drastically wrong. There have been the odd errors, there's been the odd legal challenge, and there's been the odd, like the Welsh language ballot papers of PCC elections, there's been the near misses. But the feeling is the risk is only getting greater, and now is the time to reduce those risks or eliminate them entirely by doing proper law reform.
And what is the effect on public confidence of these uncertainties?
I think it can only be damaging. And one knows from the recent set of elections that with modern social media, people who are dissatisfied publicise their dissatisfaction, and grievances are become widely known about, and confidence in the electoral process is inevitably damaged.
David Morris.
Thank you, Chair. Your interim report was published in February 2016. What plans do you have to publish a final report, and when do we expect that?
Well, since 2016, we have been continuing work on the project. We were told, after inquiries had been made within government, that there was no prospect of our main recommendation, namely new legislation, being implemented any time soon. So we have done further work on partial implementation of our recommendations, in particular recasting the elections rules, which are in a statutory instrument and don't need primary legislation. We have done a substantial amount of work on that and are now in a review point. It's our second review point. Our terms of reference stipulated a review point when we published this interim report, and the message back was no, don't draft primary legislation now. We started this rules project. We're now in a review point on it, and the question is whether we continue that work. We've already done a considerable amount, and we now have a template for new rules. We need to do more work for irritating technical reasons to produce a second statutory instrument to cover the whole field of local elections. And the question that we in the Cabinet Office are discussing is whether it is in fact a good use of our limited human resources and the taxpayers' money for us to do that. It's looking likely that we shall do very limited further work on the statutory instrument, and will instead, or having done that, we'll move smartly to producing our final report, which will be a formal document that will need to be laid in Parliament under the statute, and it will contain our recommendations as in this document, but updated to reflect the various developments that have happened since February 2016 in the electoral field, insofar as they're within our terms of reference.
Thank you for that. Are there any specific parts of the interim report that you would plan to update for the final report? Any parts of it that you think need to be reworked quite substantially?
Well, there have been various developments, various issues of contention, some of which are within our terms of reference, some are not, but we will certainly take note of all of them. We are following keenly the developments in relation to Sir Eric Pickle's proposals, recommendations, and the aftermath of those, the issues of intimidation, the issues of pressure, in particular the issues of misuse of the internet, and of course there's a wider issue of online harm, which one of my colleagues in the criminal field is doing work on, as well as our taking notice of it in this present context. All of those things will be noticed in our final report, and to the extent that they impact on our recommendations, we will modify them as appropriate.
Thank you. Thank you, Chair.
David Jones.
Yes, could you tell us who is accountable for the conduct of elections in the United Kingdom?
Depends which part of the United Kingdom you're in. The answer in England and Wales is, as in Victorian times, the local returning officer. The traditional legislation, most of which, as I mentioned last week, is reproduced word for word in the 1983 Act, enacted in a day, as I mentioned, predating the telephone. You couldn't supervise local returning officers. You had to repose the duties in them and possibly come down on them afterwards if something had gone wrong and was their fault. In Northern Ireland, the position is very different because of the creation of the Chief Electoral Officer, who supervises, I think is the returning officer for the whole province, and supervises all elections there. Scotland has an electoral management board which supervises local government elections, and the Scottish Government is is consulting on extending that board's remit to Scottish Parliament elections as well. We have, of course, the Electoral Commission, which has a guidance and monitoring function, but no powers, as far as I'm aware, of direction. So the short answer to your question is the local returning officer.
And he has sole responsibility, or she?
Yes.
As a matter of law, the returning officer is responsible for the conduct, the lawful conduct of the election. If you're looking at wider governance concerns, you have to bring in the Electoral Commission, even though it's only issuing guidance and advising. It does have a wider governance function. It reports on elections and makes recommendations for if there are problems. I think the Association of Electoral Administrators, which has no formal remit, has to be considered also as part of, it's almost a representative group of the corpus of returning officers or electoral administrators, and it issues reports after each major election as well.
Who has the responsibility for deciding if an election is safe or unsafe?
The Electoral Court.
And how is a reference to the Electoral Court made?
By I think a petition is the formal term for the document that initiates the proceedings. It's a funny court, if I may, not without disrespect say so. It's a pop-up court in modern jargon. It has no standing existence, but is created each time a petition is filed. And for parliamentary election, it consists of High Court judges, but while they're sitting in it, they're not sitting in the High Court. And for local elections, it's staffed by commissioners who, in practice, are deputy High Court judges as well. That's not a formal rule, but it happens that the sort of people who get appointed to the one tend to have been appointed to the other. The procedure is very antiquated. The statutory framework is supplemented by procedural rules, which in England at least are very antiquated. There's mandatory security for costs, which is unusual. there is no procedure for filtering out frivolous or unmeritorious petitions. They have to go to full trial. And we recommended, if you permit me to go on, we recommended that the petitions be brought into the High Court in England and Wales and the Court of Session in Scotland. That recommendation was enthusiastically supported by the Judiciary of England and Wales. It wasn't supported by the Judiciary of Scotland. But I think it's fair to say what matters more is that the procedures are modern and up to date and adequate, rather than where exactly the judges are housed in the system.
And who would have the locus to petition the Electoral Court?
Henry will remind me, it's the unsuccessful candidate.
It is the unsuccessful candidate or an elector at a parliamentary election, or 4 electors at local government elections.
So any elector?
Any elector can challenge a parliamentary election. And the risk is that if an elector has had a bad experience, was wrongly denied their vote, their only remedy is to question the entire election, which would result in its nullity. In the vast majority of cases, if your vote has not been counted or something's gone wrong with your case, you just want that grievance addressed. You have really no prospect of successfully saying to a judge, this election was wrong, because if it's just one vote. But that's your only remedy in law.
And the absence of a process of filtering petitions to the court presumably allows space for vexatious or frivolous petitions to be made. Presumably the only deterrent would be costs, which I suppose would be extremely heavy.
That's right. Cost is exposure to cost when at an election petition is rather high. There is no filter. It's a binary process. Either your electoral election petition is formally good, in which case it proceeds to full trial, often going on over many days, or it's formally wrong, in which case it falls away. Modern civil procedural rules allow a judge to exercise his or her professional judgment to say, this claim is without merit and I will stop it at an early stage after due procedure. And this claim is meritorious, or perhaps certain elements of the claim are meritorious and warrant a day or 2 in court. That is a more proportionate use of the court's time, and that saves parties costs.
And presumably your report recommends that such a process should be adopted in future to such claims.
Yes.
Do you want to hear about our proposal? I mean, in short, our proposal is the modern court system should be used by the election court. So the High Court should hear parliamentary election petitions. We're talking in England and Wales, and a deputy judge could be appointed to hear local election petitions.
And the modern set of civil procedure rules would simply apply, and it contains all the modern mechanisms that you need.
And that would, for example, reduce, if you do have a meritorious claim, as the petitioners in the Tower Hamlets case had, it would reduce their exposure to cost. The big scandal at the time was, although they had won, they had to essentially face losing their homes if they had lost, because of the cost of the other side, which they would be liable to pay.
Thank you.
Eleanor Smith?
Yeah, I'm just coming on to that. So basically, how fit for purpose is the current petition system for challenging the results of the election?
Well, it's not very fit for purpose in the respects we've been talking about. And as Henry's just said, the civil procedure rules enable cost protection orders to be made, limiting the exposure to costs of a claimant if they're eventually unsuccessful. That's another mechanism that would have comforted the applicants in Tower Hamlets, and which would be available if the civil procedure rules applied.
I agree with Nick. It's not fit for purpose. I'll just give you one example. Under the statute, the 1983 Act, it was sought to preserve the practice of the old House of Commons committee, because the House of Commons had the exclusive privilege of adjudicating upon its own election. In due course, it gave that away to the election court because it was felt that its adjudication was too partisan. But you're still meant, under Section 157(2) of the Representation of the People Act, to go back to the House of Commons practice in the 1860s, which at the time, when I was looking at it, I thought the only way to do that is to find Erskine May, the edition, live in the 1860s, and find out what the law is. Of course, I mean, now you have books and so on, so will tell you the answer. But as a matter of law, this is what we're expecting a citizen to do. It's simply out of reach of almost everybody in the UK.
Okay.
Rupert Huck.
Talking of things not fit for purpose, Election Court Judge Richard Morey QC described that 1982 representation of the People Act as which is a kind of consolidation of lots of other things. Was it the 1971 that lowered the age of franchise and all that, as a disorganised bag, and it does appear to be a bit of a rag bag. Is that a fair description?
Well, I haven't tried, as it were, to mark the 1983 draft as homework and work out whether they could have done better. But the main, or a major deficiency of the 83 Act, which is not the drafter's fault in this instance, is that it's a mere consolidation. As I say, these 1870s provisions just reenacted. If I can go off a slight tangent, David Jones may be interested to know that we reported to the Welsh Government on how, advised them as to how they should approach legislation in future. And we said, when you bring things onto the Cardiff Statute Book, don't just reproduce them, reform them as necessary as well. Unfortunately, the Westminster system doesn't admit of that. And in the case of the 83 Act, we've had a further, whatever it is, 40-something years of 1870s law.
Something that was missed out, as you were saying about the Welsh Language Act when there was reconfiguring in 1983. Do you think that was what happened?
The Welsh language ballot papers.
No, what we were saying about the not put into law with the previous question. Do you think there was some sort of slippage there?
Well, I don't know how this was approached in 1983. All I don't know is that it was a mere consolidation without any updating of what was already more than a century-old legislation to a considerable extent. I can't pass judgment on why more was not done, but 45 years later, the time is certainly right now.
It's not 45 years, surely.
No, it's 35
no, it's
years.
Not. I'm not born in that year.
No, it's 30.
Anyway, it's old. It's an eternity ago. Henry.
I'll echo what Nick has said about the 1983 Act. It was largely a consolidation, and so that's quite limiting. There was simply no scope for doing modernisation of, say, the election petition system. But I just want to stress that since 1983, a lot has happened. Our analysis in Chapter 2 of our consultation paper and the report, which overwhelmingly stakeholders, everybody who knows about elections, concerned about elections, party compliance officers from across the spectrum, cross-party agreement, that the approach that got us in trouble was that the 1983 Act has scope only for parliamentary and local elections, and then on the statute book emerge a number of new elections, and they weren't brought within the scope of the 1983 Act. So not only is the 1983 Act out of date, it doesn't govern the field. On top of that, it's been successively amended, and you can see that there are different drafting styles. If you look at the 1983 Act as original, unamended, it is a coherent act. It's technical, it's a consolidation, but it's more or less coherent. Since then, as we've innovated in policy terms to introduce rolling registration, individual electoral registration, to improve policy and modernise policy, it's become a bit more of a portmanteau.
So is it time for an update to take into account those things, and how could a new Consolidation Act avoid similar criticism, or would it require more than just consolidation and something else?
Well, we recommended a lot of technical type reforms in our report, and if we were given the green light to draft a bill, we would instruct Parliamentary Council to draft a bill which included these reforms, as well as bringing the law together into a coherent whole.
So what are the pitfalls that should be avoided this time?
What we said in Form and Accessibility of the Law in Wales is that this institutional discipline is valuable to keep a code or a Consolidation Act fit for purpose. Under the Constitution of the UK, Parliament is supreme at any point. It could legislate in a separate, bespoke, discrete Act of Parliament after the Great Consolidation. The key thing for government and Parliament to keep in mind is it would be more useful to assimilate that new measure into the Consolidation Act. That's code discipline. When we're talking about codes, it's a question of institutional discipline. There is no constitutional or legal mechanism to ensure that a new consolidation, remains in place for 20, 30, 40 years. It is simply up to Parliament.
Can I just ask a question as well in regards to electoral reform, in regards to the trade union movement? Do they come into that area, or is that separate altogether?
Elections within the trade union movement aren't governed by this legislation at all.
Okay.
It purely governs elections to the parliaments, the local authorities, mayors, police and crime commissioners, those sorts of things.
That's fine. Thank you.
Thank you. Cameron Hopkins.
Thank you, Chair. Is there a risk that even if electoral law was consolidated now in line with your proposals, it would become fragmented again in the future?
There's always a risk of law becoming fragmented again in the future, and that's why we exist, the Law Commission. The removal of anomalies is one of our statutory tasks. But having said that, I think that were our recommendations to be implemented, there would be less risk of fragmentation in the future than we have at the moment. As I was mentioning last week, we have 11 different rule books for different types of elections, portions of elections at the moment. Each one of those has to be amended if there's a change in policy. If a new elected body is created, a new rule book and set of legislation is written for it, at least that's what's been done up till now. If our recommendations are accepted, there will be in each part of the United Kingdom a single piece of legislation governing elections generally, containing differences, of course, where the character of the election requires a different method of voting, for example. It will contain differences where different legislatures want to implement different policies on things like the age of voting, which we know is under discussion at the moment. But it will basically be in each jurisdiction a single framework for the elections within the legislative competence of each of the parliaments. And so if a new elected body is created, it can just be slipped into the framework. If a policy changes, you amend one provision, whereas at the moment you have to amend you need an Act of Parliament to amend the Westminster parliamentary election rules because they're in the 83 Act. And then you need statutory instruments to amend about a dozen other statutory instruments which govern the local and other elections. There'd be one amendment per change of policy under our scheme.
Thank you. It's been suggested to us that a panel should be set up to keep electoral law under periodic review. Do you believe this would be helpful?
It's not something that we considered or have discussed as law commissions. I certainly read the professor's evidence to you for that, and it struck me as a very interesting idea, and I noted his reasons for advancing it. I'm not really qualified to comment in any authoritative way on that, but I can understand that it's something that you will be thinking about.
Do you think that keeping electoral law under periodic review is a role that sits well with the Electoral Commission? And I say this because it is possible that changes to electoral law might become politically fraught, rather sensitive, whereas the Electoral Commission wants to steer clear of that kind of political involvement. Is that not the case?
Certainly our experience of them is that they want to keep out of the fray for understandable reasons. When we suggested that there should be what we called a public interest petitioner who could petition where an election appeared to have gone wrong and none of the candidates or electors was petitioning, they did not want that role. I think you'd need to ask them rather than us whether they would want the sort of role that you're now talking about.
But I think certainly for the role we were envisaging, which would be a role to bring a challenge in the public interest of an election, I think the risks are of a higher degree than making recommendations for reviewing the law or improving. So I think the Electoral Commission itself, you'll have to ask them, but it does keep the law under review. It publishes several policy papers, and many of which have led to changes in the law.
Well, we've had recent changes in terms of elections and whatever, which have become very politically contentious and challenged between the parties. A panel separate from the Royal Commission would avoid the Electoral Commission becoming embroiled in that kind of controversy. You not think that's sensible?
Yeah.
And that is something we considered in the context of public interest petitioners, that sort of having an arm's length body from the corporate Electoral Commission, if you like, to help with that, to help with the decision to bring a petition.
And a standing body which would just be permanent rather than the occasional Royal Commission or Committee of Inquiry or whatever would be more sensible. Is that possible?
Yeah, it sounds, it's a matter for you, but that sounds plausible to me.
Right, thank you.
Thank you very much. David Jones.
Did your report come to any conclusion about the level of personal liability faced by agents for a candidate at elections?
No, I don't believe we did. I know, particularly from hearing those who addressed you after us the other day, that this is now a source of anxiety to agents. My understanding is that it revolves around the demarcation between local and national campaign expenditure, which is a matter that lay outside our terms of reference to the extent that national campaigning was firmly excluded from our terms of reference. So we weren't in a position to address that issue of the demarcation.
This isn't something you could possibly stray into before you complete the publication of your final report?
We're always open to being given work where it's valuable. We would need to consider whether it was a matter that we as unelected people had a mandate to decide upon. We take the view that we can make common sense proposals based on understanding of the way the law works. We can't make pure value judgments or political, big capital P judgments. We'd need to discuss with stakeholders and the Cabinet Office to ensure that this work fell on the right side of that line. If it were thought to do so, I'm sure we'd be prepared to do it. The issue is whether we should hold up moving to the final report, because clearly further consultation would be involved and it would add several months. It might be better for us to polish off the final report and then be given that task if it were thought appropriate.
Given that, as you've said, that we've heard informally that there's a degree of concern about the personal position of agents, is this something that you would be prepared to raise with the Cabinet Office?
I think we're certainly prepared to raise it with them.
We will, as we are looking towards work, wrapping up our work in a final report, we will be having discussions with all stakeholders, including the Cabinet Office, the Electoral Commission, just to gauge what has changed since February 2016. As you've noted, quite a lot has changed. What I can say about our work so far is it's looked at the law on the regulation of the campaign at a local level, but not with an intensity that extends to rejigging the system. We have made recommendations, for example, that such expenditure limits as are currently very difficult to determine or lots of people have to use a formula in order to find out what the precise limit is, that should be made easier, that should be declared. But what we haven't done is question the orthodox orientation of the regulation of local campaigns, which is to really channel everything through the agent and the candidate and place personal liability on them. That's been the law since 1883. We did not recommend that should be disturbed. So I just want to be clear that our work so far has not looked at the personal liability of the agent, but we'll have discussions with officials.
Thank you.
Alan Smith.
Why do you think there has not been substantial progress by the government in taking your recommendation forward?
I think it comes down to pressure on parliamentary time and issues of what nowadays is described as parliamentary arithmetic. I'm not sure I need say much more than that.
Thank you. Can I ask, David Jones, sorry.
Yes, in your submission you said that in the absence of primary legislation you were looking at what could be achieved through secondary legislation. What progress has been made on this?
We have drafted, we've done as much work as we can on producing a statutory instrument which, if it were made, would contain the rules for quite a number of elections. As I mentioned briefly earlier, we have this slightly frustrating situation where the rules for ordinary or traditional local government elections are made under a rulemaking power which involves the negative resolution procedure in your House, and the rules-making power for other elections involves the affirmative resolution procedure. And it is not possible to make one statutory instrument containing material that requires different procedures. So, as the statute book currently lies, we would need to produce two statutory instruments largely mirroring each other. We've done one of them. The question is, do we go on and do the second? It's very labour intensive. The devil inhabits the detail throughout. And we think it's probably a better use of our resources and the taxpayers' money for us to move on to other areas of work. Sadly.
To give us a flavour of the work involved, how big physically would these statutory instruments be?
It's got to 40 pages already.
Right.
It's involved the laborious task of opening all the existing rule books for these different types of elections, trying to copy them into one rule book, continually coming up with the niggling inconsistencies that I have mentioned earlier, deciding to the extent we can which form of wording should prevail, leaving it to others to direct us where a political judgment has to be made as to which of different systems is the better. We were allowed to use Parliamentary Counsel, a parliamentary drafter, to do most of this work, and that was extremely valuable. It was certainly regarded within that office as a task worthy of a parliamentary drafter. And I hope that what we've done will be useful in the future. But there doesn't look to be much prospect of a statutory instrument being made in the near future, even on the basis of the work we've already done.
Okay. Thank you.
Moving on to the standardisation of electoral law and devolution. Constitutional matters are in principle reserved, and therefore your recommendation that we should have a consolidated Elections Act for the whole of the United Kingdom should be quite straightforward. But are there any proposals, do you think, in your mind's eye that would actually require legislative consent from the Scottish or Welsh or Northern Ireland parliaments?
In broad terms, legislative competence over elections to this place, it is in this place. The United Kingdom Parliament makes the law for United Kingdom parliamentary elections. But under the Scotland and Wales Acts, competence in respect of the devolved Parliament elections and local elections in those two countries has been devolved. So our recommendations would need to be implemented by a piece of Westminster legislation governing this Parliament and pieces of Holyrood and Welsh Assembly legislation governing elections in those countries.
Does that mean there's a certain amount of duplication involved, or does that mean that they're encouraged to do something different?
Well, we would encourage them, insofar as possible, to do the same thing. We didn't think it was for us to speculate on whether they would agree to give legislative consent motions or not, so we've operated on the assumption that they will enact their own legislation. But insofar as it concerns the mechanics of running an election, we recommend consistency, because returning officers in those countries will be not infrequently conducting elections to this Parliament alongside elections either to those parliaments or more probably local government elections in those countries. And it would be unfortunate if more inconsistencies were created by virtue of the Parliament's legislating differently for the mechanics of elections being conducted simultaneously in those countries. We're optimistic it won't happen in view of the considerable work that's been done in reaching a joint position on the canvass. You'll be aware of a joint publication by the three governments on that front. And where one's talking about the mechanics of running an election, it seems unlikely that the devolved parliaments will want to differ. On matters like the voting age and other matters of policy, they are entitled to it. It is their right.
The SNP submission suggests that policy divergences an inevitable consequence of devolution and must be respected. How do you work with your Scottish counterpart in order to bring about that consistency in the mechanics that you want? And are there areas where you think there will be differences?
Well, if the two commissions were tasked with preparing bills for our respective parliaments, legislative competence for Northern Ireland is held in Westminster, as it happens, my understanding. Yeah. But just thinking of the Scottish government and the Welsh government, if we and the Scottish Commission were tasked with producing legislation not only for Westminster in our case, but Cardiff also in our case, and Holyrood in the case of the Scottish Commission, we would, consistently with our recommendations, exhort them to follow the same, adopt the same rules on matters of pure mechanics, while respecting their constitutional freedom to depart from each other on matters of policy.
What would be the effect of legislative consent being withheld by Scotland and Wales? I suppose that's depends what it is.
Well, I think it's not controversial. Both the Scotland and Government of Wales Act recite the Sewell Convention. You will not normally do so.
But are you saying that therefore there should be a UK Elections Act, a Scottish Elections Act and a Welsh Elections Act, that somehow we hope that they will all dovetail neatly together and provide a consistent application of principles, mechanical principles?
Yes, well, as I've said, we don't think it's our business to recommend to the Scots or the Welsh that they give legislative consent motions. That's entirely a matter for them.
If they have a separate... But in the end, you would accept that there has to be a separate Scottish Elections Act?
Absent an LCM, yes.
Right.
Can I just say a little bit about that? When we published the interim report, some devolved powers in Scotland existed for local elections, and we knew that they were on the way for Scottish parliamentary elections. We also knew there was going to be greater devolution in Wales. That's why we made our recommendations subject to the devolutionary framework. Now, some divergence is an inevitable consequence of devolution. That's just a constitutional fact that we accept. The thing that we stress is that in the past, when, for example, for the Scottish local government elections, there has not been a radical departure away from the way elections are conducted and administered. The reason why is because Scottish electoral administrators have to conduct elections according to both governance frameworks, the UK statute book and the Holyrood statute book. And the thing to bear in mind is, as the experience of the voter diverges, that they are informed. In Bromley, for the European parliamentary election, my election communications stressed that I did not need voter ID because it had been a test area, it had been a pilot area for voter ID. For the European parliamentary election, they knew that they had to tell their voters, for this election, you do not need voter ID. That's just to use one example of possible divergence in future between England and Wales and Scotland, and between England and Scotland and Wales. Voter education is the key.
Thank you. Rupa Huck.
Yeah, I wanted to ask about the residency test as another aspect of potential electoral fraud. In your interim report, you say that there's no guidance in primary or secondary legislation for electoral registration officers, and I think in the Pickles review they said that there should be some definition in law of what's a second residence. Do you have evidence of inconsistent treatment by different registration officers because there is no agreed definition of what is a second residence?
We have anecdotal evidence, probably hearsay, but from sources we trust, that in some areas where there are a number of second homes, registration officers do take different attitudes, from not questioning the residency status of the homeowner to requiring a lot of proof. We didn't think it was for us to opine on whether people should be entitled to vote at a second residence. Different interests are at play there. I remember from my undergraduate days that students have long been registered to vote in their university towns. The other main category, of course, is second homeowners. All the law says is if you're a resident, you can be registered to vote. It doesn't give any guidance on what being a resident means. And of course, there's a grey area between what is genuinely a second home and what is an occasional holiday place, albeit owned by the owner. We suggested that there should be some statutory factors to be taken into account, such as frequency of visits, length of occupation, number of nights of occupation in the year, and that sort of thing, which we thought would assist registration officers in being a bit more consistent than it appears anecdotally that they are.
I mean, when I worked in academia, often students would be registered at the University of Manchester. They registered everyone in blocks sort of thing, but then you could only vote once. If it's held in term time, it makes a difference. You
can only vote once in the same election, and it's a crime to vote twice. So if you have two residences, you can't vote in both constituencies in the same election. You can vote in the local government elections in both places because obviously they're separate elections.
What difference has individual registration made, and do you have any examples of that inconsistency that you said that different officers interpret it differently?
We, as I say, all we have is sources we trust telling us that these inconsistencies of practice exist.
Yeah.
Individual registration hasn't made any particular difference to this aspect of things. But we did, well, to mention...
Sorry, can I just say that
Yeah.
there was a concern
There
when
must be.
IER was introduced,
Yeah.
that household registrar, because essentially the
Doesn't just
registrar
roll
in the university was block registering all students. My understanding is that's been addressed. I don't know exactly how it's been addressed, but you can ask the Electoral Commission or the AEA about that. That is no longer a concern. The universities have found a way to get students
I
on
think
the
it's something
register.
like when you register, it's a button on the thing when you're getting your student ID in the beginning. That's what I've heard anecdotally.
I think there are a number of ways, on top of which there is the online registration system. Sorry, Nick.
I was only going to say, for completeness, the one recommendation we did make is that a person who is registered in 2 different parliamentary constituencies should be required to say which one he or she will vote in a parliamentary election. They can change that option from time to time, but the result is they only get one set of voting papers in one place, and they're prevented from, whether by inadvertence or design, voting twice in a parliamentary election if our recommendation is implemented.
Something MPs are very familiar with is receiving ballot papers for 2 addresses. Because
Some only have one house.
some only have one house, but anyway. Dame Cheryl.
Yeah, no, I was just interested in your comment that that you think that there should be some residency test and the numbers of nights spent in whichever property. How could you see that working? That seems to me like a fairly heavy-handed invasion of privacy.
We didn't suggest a test in terms of a strict number of nights, but we suggest that the law refer to those factors which, as a matter of common sense, help you decide whether somebody's occupation of a place amounts to being a resident or not. And frequency of visiting to the place, portion of the year as a whole spent in the place, all those things are relevant. But of course it's got to be a loose test rather than a rigid tick box approach.
And how would you envisage making those inquiries of the citizen? And
It would be at the stage at which they apply to register. What we recommended was that they would be asked to state whether this was in respect of a second residence. As per the current law, there would then be scope for writing to them or talking to them, which there is currently scope for. It's just it never happens. But essentially, all we sought to do is to direct the mind of registration officers that the law isn't you can never be second resident in respect of another place, and it isn't you can be resident anywhere. We don't need to check.
I mean, how far would you take this? What about people that work abroad or don't know, where they're going to be working at any one time? I mean, you seem as if you're opening Pandora's box here.
Well, I think what we were trying to do was assist in a situation where the law admits of you being resident in 2 places and evidence that this was causing problems of inconsistent application. It's open to parliamentarians, but not to us, to say second voting place should be verboten, or to say ownership of 2 properties automatically carries 2 votes. The current law is somewhere in the middle, imposing this test of are you a resident in both of the places, and we were simply trying to assist registration officers in answering that question.
Thank you.
Interesting. Calvin Hopkins, the Pickles Review.
Lord Pickles' review argued that the law on undue influence needed to retain a reference to spiritual injury. Your proposed offences of intimidation, deception and improper pressure do not include such a specific reference. How should the question of spiritual injury be addressed?
Well, we preferred the general formulation of improper pressure, which can include religious pressure, spiritual pressure, or however one likes to put it. It didn't seem to us to be necessary to itemise different types of improper pressure, but rather better to leave it that improper pressure is an offence, and it's for the court to decide whether the pressure whether it be invoking hellfire, which was what the provision was originally. I mean, this dates back to Catholic clergy in Ireland before 1933. That's what it was targeted against. It came to prominence again in Tower Hamlets, of course, in 2014. We don't suggest that there should be carte blanche for people to impose improper pressure of any sort, including based on religious authority, but we didn't see any need for singling out religious pressure for explicit mention in our new legislation. One does also have to be careful of Article 9 of the Human Rights Convention, freedom of belief. At the moment, it's perfectly open to somebody to suggest that a particular candidate's policies are contrary to some ethical standard or other. And it's debatable whether religious leaders should be in any different position as regards debate at that level. If improper pressure in the sense of abuse of religious authority is involved, then under our provision, like any other form of improper pressure, it will be potentially criminal.
Might it not be sensible to have some reference to spiritual injury or that kind of influence, just as a kind of token warning to religious leaders not to abuse their position in this way? I take an example from 50 years ago, so it's well past and certainly not now controversial, but a particular case, and I was told about this personally, of a religious leader in a particular area, in a local ward, where there was a particular concentration of somebody from a particular faith, from that faith. And the religious leader used to say, vote for the people of our faith first, and then for a particular political party after. And we saw dramatic results where the one person from one party with religious faith got several hundred votes more than the other members of that same party, and he was elected, and the other party had two elected. So it worked in that case. Now, it may not be significant now, but the Tower Hamlets case certainly suggests that religious leaders ought to be informed that putting undue pressure on their constituents in that way is inappropriate in a democracy where it's an individual choice. You can choose for whom you vote based on their policies, and you should not be intimidated or pressurised because of religious belief.
Yes. Of course, the original, the still existing provision criminalises threat of spiritual or temporal injury. So just saying vote for so-and-so because he's a good churchgoer wouldn't be criminal, but threatening hellfire or damnation was plainly what the draftsman had in mind. So one does have to be very careful with the extent to which one limits debate with criminal sanctions.
I have some personal experience of this. In 1983, I stood as a candidate for Parliament. I lost by several thousand votes, so marginal votes would not have made a difference. But I was challenged publicly about my views on abortion, and I said I believe absolutely in a woman's right to choose. I was told very strongly that people didn't agree with me. And I said, we live in a free country, one can vote against me. You know, and I've always said that. If you don't agree with me, vote for someone else. But whatever. But amusingly, I was told later on by somebody from this community, I don't agree with your views, but I'm still going to vote for you. Anyway, it was an experience. Thank you.
Well, I think we've finished our questions. Thank you very much indeed. And we will move on to the next panel.
Well, thank you. We're very pleased to have been able to come along and hope we've been of some assistance. And
thank you very much.
If you need anything more of us, I hope you won't hesitate to ask.
Well, I think we would be particularly interested in you looking at the question of the degree of exposure that agents are now exposed to, financially and legally, which is potentially going to discourage participation and the proper conduct of elections. It seems to me that is a technical legal issue as much as a policy question, and I would hope that you would address it.
Can I apologise? I think I made a mistake. I want to draw the attention to a mistake. I was asked who can challenge an election. I believe I said 4 electors can challenge a local election and 1 elector can challenge a parliamentary election. It is the other way around. I made a mistake. I failed to note your...
open of you to correct that. So
very quickly. Sorry about that.
But I hope that's not to distract from the other point I was making. I think the committee has really seized that this is a very, very serious detriment to confidence in our democratic system if people are discouraged from taking responsible roles. We would be grateful if you looked at it.
Yes, well, we've noted that. Thank you.
Thank you very much indeed. And can we have our next panel of witnesses, please? Welcome to our second panel. Could I ask each of you to identify yourselves for the record, please?
Yes, I'm Louise Round. I'm the Chief Executive at Tandridge District Council, and I'm also the elections spokesperson for Solace, which is the Society of Local Authority Chief Executives.
And I'm Peter Stanion, the Chief Executive of the Association of Electoral Administrators.
Well, thank you for being with us. Can I ask, first of all, how urgent do you think it is to update and consolidate electoral law?
Pretty urgent. I echo everything you've heard from your speakers earlier on in terms of the sheer complexity of trying to navigate your way through elections legislation, particularly as it's usually a fairly heightened atmosphere. You're trying to do that within a fairly short order often.
I'd echo that. Everything that was said earlier in the earlier session. It's getting more complicated. I first came into this profession 30 odd years ago, and since about the year 2000 has been constant change all the time, but the point being made that it's legislation made in 1872 that we're still bolting things onto. And I think the point was made earlier with regards to, is there a catastrophic thing that will go wrong? Elections will always work. It's the fact there's lots of little things, technical things, that actually bring that risk into the actual process that make the need for change more urgent by the day.
And what do you think are the most practical and immediate risks that we could use as examples in our report to amplify the point?
From the AA's consistently made the point is that we're dealing with, I think Nick and Henny mentioned 11 different sort of statute books that we do for different elections. It's a lot of the process is the same regardless of the type of poll that's being run. But with the changes introduced by things such as individual electoral registration, rolling registration, postal voting on demand, the future proposals for overseas electors and the like, it's really a lot of the issues are around the timetabling of how it all comes together, how all of the different constituent parts play out, because certainly in England and Wales, the same people who are running the electoral registration process are the same people delivering the election. And what's now happened is that electoral registration seeped into the elections process. And many of the issues that have been experienced over the last few years have been registration issues occurring during the elections timetable. So it's trying to stand back and have the process in place that means that each of the constituents' parts can work side by side to take the risk out of the election as it works its way down the line.
Yeah, I think many of them will be technical errors and will go unnoticed and probably wouldn't really go to the validity of the election. But in terms of confidence in the system, if one's being challenged by agents or party compliance officers and it's a bit wrong, it may not be the end of the world, but a bit wrong is not really good enough when people then begin to worry about what else might have gone wrong behind the scenes. Probably nothing, but it's just not good for public confidence in the system if people are having to say, I'll come back to you, I'll look it up, or I looked at the wrong bits of legislation, or it's out of date. Not to mention the pressure it puts individual officers under when that's happening to them at the same time as they're dealing with late deadlines for registration, etc., etc.
Well, thank you. And moving on to Rupa Huck.
Yeah, those little technical things you were talking about include referenda that we've had many times in recent years, and the internet, which was not anticipated in 1872 or even 1983. How difficult is it to administer electoral law in its present state?
Very wide question. It's understanding the changes that have taken place and what the impact is on the actual process. So taking individual electoral registration has been a really good example. The access to the system cannot be doubted. It's been a real big positive. But I could sit there at a desk in the council offices at 10:05 after a leader debate, and you will see the spiking registrations going up at that particular point because people switch to the smartphone. I'm not sure if I'm registered. I'll go online and register again. If they're registered, that's fine, but the process takes time for the administrator to actually make sure that is the same person, that they're already on and not. So it's the access is very, very good for the citizen, and no one can actually knock that particular process. But it's adding the pressure in very late to the day. The best example of it was in the run-up to the EU referendum, where the government portal crashed literally an hour before the midnight deadline. And the decision was taken to extend that deadline by 2 days, absolutely valid in terms of ensuring citizens could register. But the implications were knocking on significantly to the election because poll cards couldn't be sent out, postal votes had to be delayed, ballot paper, you're knocking into the elections process. So every time a change takes place to the system, the key point is the implications elsewhere in the system, because it is the same people basically running both parts of that.
And I suppose just linking to that, most local authorities now are shrinking. So in terms of the legal support, actually the lawyer's interpretation of what a piece of legislation might mean at short notice, there aren't people sitting there with this sort of expertise that Mr. Payne QC has. They have to go and look it up, and actually if they don't know where to look, they don't know where to look. It's not immediately obvious which piece of legislation, which piece of secondary legislation, which schedule as amended to go to. It's a bit better now that you can do legal research online, because in the old days you had to just hope that the Encyclopedia of Law, which is a physical document, had been updated in time and someone had put the right pages in the right place, which they didn't always manage to do. But even some of the legal online research providers can't keep up with the number of legislation, so there's always a risk that even if you find the right bit, it's not been updated properly.
Do you think the sanctions are enough when electoral law is broken? The fine for vote leave, which they were going to appeal, and now they've dropped that, almost admitting...
Probably not for us to comment on that.
If I just add to what Louise mentioned in terms of the complexity, looking ahead to May of next year, with the elections taking place, you've got the Police and Crime Commissioner elections, Combined Authority mayoral elections, District Council elections, Parish Council elections, all different returning officers, but nowhere in law does it say who is the one who actually has the overall control over the whole election. And because the PCC and Combined Authority in certain areas are regional elections, they may well be deemed to be more important than the districts. But if you ask the districts, they're more important than the Combined Authority mayoral. That's not codified, and it will be sorted in terms of returning officers talking to each other, but there is also the potential for there to be, well, I'm sorry, I'm counting my votes here, rather than actually bowing to a different view. So it's those sorts of things that the different streams are not obvious, but they will have to be played out between now and May of next year.
And snap elections, I guess this last European one wasn't anticipated till quite recently. Do they put pressure on the system even more?
Absolutely, absolutely. In fact, I think talking to colleagues, I think it was a 27-day election for the European on a regional basis, and that actually was harder to arrange than the unscheduled parliamentary election, because actually all of the work on communications for the parliamentary is done through the wider media. For the European, there was confusion, so that's it adds complexity, I think.
And in some places in districts, we were still running the district elections, so we were running two elections at an overlapping time with slightly different timetables and slightly different rules, with a core team of about 3 or 4 staff.
How much do you, as an electoral administrator, dread elections coming round, how much do you feel personally, either reputationally or even financially exposed to perhaps making the wrong decision or failing to spot something that was going wrong in time? I mean, how onerous is the responsibility?
It's both an honour and onerous, in the sense that it's fundamental to our democracy that these elections run properly, and to do it right is incredibly satisfying. But at the same time, acutely conscious that if you do it wrong, you may have disenfranchised someone. There's the risk of electoral petitions with the consequent costs. We're personally, financially liable as returning officers. So there's always that quick check with our insurance policies that they will cover us for the election that's coming up, and the quicker they come up, the more likely you might be to forget to do that. They have excess. Our local government election insurance policies have an excess of around £75,000, which might be all right for the councils, probably not great as an individual. So absolutely we feel the pressure. We're glad to do it, but certainly in the sort of 3 or 4 weeks running up to the election, and particularly at the count, when it all comes together and you'll know whether it's gone right or wrong, the pressure's huge.
Anything to add?
I'll just echo those thoughts, other than to say it's easier to plan when you know the election's coming 6 months out than it is when it's 25 days away. So,
yes. David Jones.
Yes, I think you were both present when the first panel gave evidence, and you would have heard them say that returning officers are exclusively accountable for the conduct of elections in this country. You agree with that analysis, I take it. You've just indicated the extent to which returning officers can feel vulnerable and exposed. What support do returning officers have from other organisations, whether before the election or in the heat of the election itself, on election day?
Generally, we work really closely with our colleagues in the AEA. Part of my role in Solace is to try and improve the degree of support we give each other. So there are a few of us who have been around the block a few times who will always be on the end of a phone if people need some technical emergency support, as it were. But I think we need to think about how we refresh our training for returning officers. Some of them will come into, they're not always chief executives of councils, but probably a majority are. They may come through the ranks of local government, become a chief executive, having been responsible for social care or something in the past, so that might be the first time they have to be a returning officer is within a few weeks of the election coming forward. So we need to make sure that the training and induction and support given by Solace and in conjunction with the AEA and the Electoral Commission and the Cabinet Office actually is proper and coherent, and so it's both good training and then someone to call on the day when it's not going as well as you would hope.
And who is available, Mr. Stanton, at the AEA to respond on the day if there's a query from a returning officer in distress somewhere in the country?
There will be myself, with the experience that I'm able to give. I've got probably 2 or 3 colleagues who will be on the end of the phone. We're a very small organisation. And I think the crucial bit to it is that the AEA, the Electoral Commission, Solace cannot tell a returning officer what the answer is, because there's personal liability to that answer. It generally tends to be these are the options you've got available to you to resolve the issue that you're facing, but ultimately it's your choice. And that's why I think the reason elections work well, are run generally very well, is because of the peer support around from colleagues at returning officer level, electoral administrator level, with the Electoral Commission being able to provide as much support and guidance as well. But it ultimately will rest in the laps of people like Louise in terms of which is the right decision to take at that right moment.
The Electoral Commission do have they do have a duty system, so they have you have a regional support officer whose mobile number you have for 24 hours through the electoral period. But as Peter says, it's not, it's advice rather than direction.
And is that 24-hour number heavily used at election time?
Not aware. I can't comment on the electoral commissions. For myself, I think in the run up to the locals and Europeans, I would anticipate 4, 5, 6, 7 calls a day. It just depends on what the issues are. A quieter election, get fewer calls.
We've heard that election courts are responsible for adjudicating as to whether an election result is safe or unsafe. What is the role of the returning officer before then? If a returning officer had a concern that there had maybe been malpractice in the conduct of an election, what would be the returning officer's role in those circumstances?
We'd have no role in the electoral petition process.
But prior to that, if you as returning officer suspected that there was large-scale abuse of the system, to what extent would you intervene?
If it was something within my own control, obviously that would be something I'd have the responsibility to sort out. If it were a fraud issue, then it would be a matter of contacting the police. So
you would refer to...
If I believe there was electoral fraud being committed, I would contact the police. We often get queries on the day or in the run-up to the election about other electoral offences, which there's some confusion about who's responsible for those, and that's also we refer those to the police or up to the commission, although they would refer back to the police. I have to say the police sometimes are very good. They appoint a single point of contact. They're not always fully aware of what the actual law is themselves because it's so complicated. So, but if it's a criminal offence, it's the police's jurisdiction.
If the returning officer has sufficient concern, can he or she refuse to make a declaration in an election?
That's not my understanding that we can.
I don't believe the return officer can. They've got a followed process. I speak from experience where we did something we were aware that, there's an allegation of a incorrectly completed consent nomination at a local government election, which we passed to the police, and then it subsequently went through to a conviction. It was had our brain cells ticking over, would we allow that person to be elected to the local authority if they got the most votes? And I think the view we came to was you would have to, because that's what the process actually is. Fortunately, they didn't get enough votes to be elected, so we didn't have to actually cross that line. But Louisa's position, return officer's position, is very much to comply with exactly what it is that the book says, and then it is full process, which may be petition to actually confirm whether or not that action is correct or not.
So even if you have suspicions of large-scale fraud in a particular election, all that you can do is to make the declaration and then refer the matter to the police for investigation.
Yeah.
Yeah. Thank you.
To what extent are the police an appropriate resource for adjudicating on whether to prosecute on an electoral offence? I mean, you say that they appoint an officer who might gain a bit of expertise, but it does seem odd that we're preoccupying the police in such a technical area.
I think that's a very valid point. Last year I had a case around a complaint that there was no imprint on a leaflet, and I referred it to the SPOC, assuming it would wend its way through the sort of the process. Single point of contact, the police contact appointed for our area. But actually, they called the agent in. The local sergeant called the agent in and gave them a ticking off, which is quite entertaining, actually. I wouldn't have thought they'd imagined, and I would have thought that the process would have been a lot more, have gone up much more up the ranks of the police in Surrey to do that, but they didn't. I think on the spur of the moment, you probably have to resort to that kind of activity. In the longer run, I'm imagining if it went to prosecution, obviously that would be a CPS issue and detailed legal advice from those that know.
Dame Cheryl?
I suppose I ought to declare an interest, as I'm one of the returning officers for a fairly low-profile election that's going on at the moment. But I just wondered, Mr. Stannion, how wide your advice is offered to returning officers. Do the political parties ever approach you about the elections, for example, that are going on for the leader of the Liberal Democrats and the leader of my own party?
We've never, I tell a lie, sorry. I've been approached once by a political party when postal voting on demand came in and they wanted to understand the handling aspects of postal votes and the like, and that was to a local constituency party. But generally, no, we don't have regular contact with political parties. It's something I think would be helpful to do, I have to be honest. In terms of the advice to, the way that the process really works, I would guess, is that returning officers there's a number of routes through Solace, through ourselves. It's also those who are delivering it, which is where we're able to provide that guidance as to what you might consider you do. A lot of that will come through the training that we deliver directly. We've got a qualification that is now widely held as being required by electoral administrators. So When the AA was set up 31 years ago, it was basically because there was nothing in place at all. So the reason it's developed into the body is because it's about the sharing of good practice, and we work alongside electoral commissions, solace, etc., to do those sorts of things. But there's no right or wrong way, because what the issues are in Birmingham will be completely different to the issues in a smaller local authority, just outside London, for example.
So I take it from your answer you'd be very willing to provide training to individuals like me or within any political party that found themselves as the returning officers for any election to...
Absolutely. I think a lot of it comes down to what is process. It works the other way as well, in terms of the 650 local authorities or constituency returning officers, effectively, will all be individually undertaking briefings with parties, agents, candidates, prospective candidates for election. One of the big frustrations is to make sure that the nomination paper that comes through is actually exactly right, because we don't want to have that debate. We want to understand the process about postal voting, we understand the deadlines about registration. So anything that will actually mean that the local activists and the national parties fully understand actually what is on the other side of the fence. The returning officers or registration officers are not trying to be difficult, they're just working to the rules that are set, I think will be very helpful.
I probably need your phone number. Thank you.
Eleanor Smith.
Thank you. What is your opinion of the Law Commissioner's report?
It's very long. The fundamental tenet underneath it, that the law needs reform and consolidation, I think everybody in the business, as it were, would agree with, for all the reasons we've just explored. It's very thorough. Not all the recommendations everyone will agree with, but I think the vast majority of what they're recommending was supported more or less unanimously by their stakeholders. So I think it's a very thorough and commendable piece of work.
Absolutely agree. I think it goes to the technical. It's not that in many respects the high level sort of stuff. You know, in many respects, the memorandum they were working to was slightly constricted in terms of consolidation of the existing law. Maybe we've reached the point now where we actually need to start to look at what is the law for 21st century, rather, because since they did their report, they really talked about the fact that individual electoral registrations kicked in, and the whole focus of registration is different now, and other elections have come in on top of that since as well. So some brave decisions in terms of changes.
So do you think that there were points of the law that they didn't consider that you would regard as a priority for the reform?
No, I think, as Peter says, at the time when it was written, it covered everything I would have expected it to. We are now moving in London to electronic counting, and what is going to be the position around electronic voting, if ever. But those were probably not sufficiently close to people's thinking when the report was written.
I think the other one that was specifically not considered was boundary maintenance. We've got parliament places boundary reviews going on at the moment, run by local authorities. We've got the local government boundary reviews, parliamentaries in the offing, for example. At the moment, there's a disconnect between all of them. So that was not looked at, but maybe something that in the future ought to be considered in the round.
Yeah. I suppose going back to the urgency point, I think what we wouldn't want to see is this consolidation waiting for all those new things to come on stream. It would be better to have a clean sheet, as it were, with one piece of legislation that embodied everything, and then amend that rather than wait and wait and wait.
Okay. And it's been suggested to us that there should be a panel set up to continually review the electoral law to keep it updated. Would you welcome such a proposal?
Yes, I think, as in the previous answer, that's the Law Commission's role, but certainly needs to be kept an eye on, otherwise we'll be where we are again in 50 years.
Absolutely agree. I was quite taken by Dr. Clark's proposal, because it does bring in the fact that it then doesn't become huge change every 35 years. It becomes more of a gradual change that is appropriate, and a lot of the unknown or the unexpected consequences can be actually removed by further thought from what's the implication over here on the other side of the coin.
Thank you.
And now David Jones.
Yes, you have had the discussion before the first panel about the level of personal liability of election agents. Is it your experience that people are being put off becoming election agents because of that level of personal responsibility?
I haven't particularly noticed that. It's the same agents pop up every year, but that's that to be expected, I suppose. In my own area, there's been a huge increase recently of independent candidates or candidates from residents' associations rather than from the main political parties, and I do think that's another argument for making the law clearer, because they haven't got the backing of the political party machinery behind them at all to give them advice. But I couldn't say I'd noticed people being off-put being agents one way or the other.
No, I think it's become more complicated recently. Certainly, one of the advantages to the electoral community is the fact that if there is a query with regards to a number of the agent responsibilities around expenses in particular, it's liaise with the Electoral Commission because they are the arbiter on whether that's right or not. So in some ways defensive, it's talk to them. But it is certainly become more complicated with the changes to party political rules and donations and the like, that I wouldn't necessarily say I'd seen people not being put off by doing that, but equally you can see the faces dropping when they see the paperwork and the responsibilities that lie with them now as a result of their roles.
Did the Thanet case change anything at all, do you think?
It raised awareness of the risks between that national and that local, and I'm not sure anybody had really worked that through. I've not seen any actual perceptible knock-on effect from that particular case, other than it is something that everyone now is aware of the need to be very clear as to where the accountability lies.
It is, of course, a very recent case.
Absolutely.
Do you, I suppose you do, speak regularly to election agents about their responsibility? You haven't noticed a change since the Thanet case?
No.
No. All right. Thank you very much.
Kelvin Hopkins.
Thank you, Chair. For in-person voting, how big a risk is personation?
I don't think it's a huge risk. I think you have to be very brave to turn up at a polling station and pretend you're somebody else knowingly. So I guess this is questions aimed at the voter ID proposals that have been piloted over the last two sets of elections. I think so. The view of Solace is that it's a disproportionate response to a relatively small risk.
Thank you. Well, the public seems to agree with you because they put their major concerns at the influence of large financial donations, number one, the accuracy of the voting register, number two, and media coverage, number three, and way down and way below those opinions are concerned about the impersonation. So you don't have any evidence that there's a big risk. But if, as has been suggested, there was a national rollout of voter ID, it has been suggested that this will pull up the drawbridge, make it impossible for some 3.5 million voters to vote, which would be damaging to our democracy and might even have political implications favouring one party or another. What are you going to? What is your reaction, or your view of the compulsory voter ID?
I think the different techniques that have been trialled in the pilots don't all rely on someone having a pre-existing identity card like a passport or driving licence. There are ways around people who wouldn't have the right documentation, and my understanding from the evaluation of the first round last year, we haven't seen this year's yet, is that very few people were turned away from the polling station as being unable to vote. What that doesn't capture is people who didn't go in the first place because they were off-put from voting, and it's be difficult to use turnout figures as a benchmark for that because they do vary from election to election. I suppose what would worry me the most if 2022 is going to be the next general election and if voter ID is going to be rolled out across the country then, and it will be combined, for instance, with all our London elections that year, then you're talking about a huge increase in turnout and a much more complexity around the sheer volume, and therefore I think the risks of disenfranchising people will increase the more people, the wider when it stops being a pilot and becomes a universal provision. I think there is a risk that people will not turn up or not be able to vote when they do. And
I think that's demonstrated. The pilot demonstrated on the lower turnouts that it was capable, and the returnouts of their teams did very well in each of the pilot areas for the two elections. As I say, we wait for the outcome of the evaluations for the last round of pilots. But the big concern that the AA has is the fact that the first full trial will be at the 2022 parliamentary election, which, as Louise says, will be not just that one election, it's combined with others. And effectively that will be with local authorities who have not put themselves forward to trial it. It will be with everybody on that basis. So we're slightly into the unknown when it comes to that.
But from what I've said earlier about the likelihood of 3.5 million people being denied the vote if a system of voter ID with photo ID was introduced, but the Pickles Review suggested that voter identification should be brought in for precautionary reasons. To what extent do you agree with that?
I don't.
Yes. Well, I think that's a helpful answer. But on the other hand, the voters must have confidence that the elections are legitimate and law-abiding. Finally, what voter ID requirements do other countries have?
The most Estonia is the best example with they're all electronic voting, but with the ID cards, there are various countries across Europe, but it all links back. In all of those instances, it's where they have got. In Switzerland, for example, I'm aware they do have some degree of voter ID, but it's where they have an ID requirement anyway, a citizen ID requirement that is easy to link to, and that is probably the biggest challenge for the proposed rollout of voter ID here, is that there isn't that card that's available. If we look at Northern Ireland, we already have that system in place, but it's with the backing of the Electoral Office for Northern Ireland issued voter ID card where an individual doesn't have their other form of photo ID. So in Northern Ireland they've dealt with it in a certain way, which is not the way it's being looked at for the rest of the UK.
Northern Ireland, we understand, has been a special case in the past,
yeah.
But you're suggesting that only those countries with ID cards in general use would...
To my knowledge, yeah. To my knowledge.
But other countries who don't have ID cards, like Britain, would not be required to show photo ID.
Not that we're aware of,
yeah. Thank you.
Dame Cheryl.
But doesn't the production of ID and photo ID increase public confidence in the process of elections? I've just led the Council of Europe election monitoring team in Bosnia-Herzegovina and was part of the Turkish monitoring team. And it seemed to me that the production of ID in those instances made people have much more confidence in areas where perhaps they have some reason to have less confidence in the electoral process. So wouldn't it be a good thing for increasing public confidence, first of all?
The British electoral system is based on trust and has always been based on trust. And interestingly, the only questions that can be asked in a polling station: are you the person shown as X on the register? Have you previously voted? And if it's a yes and a no, then that's the process. So there is no evidence of there being significant voter ID voter fraud taking place. That's I think recognised. But equally, the key point to the process is exactly what you said at the beginning. It comes down to what is the trust in the system. Any returning officer and electoral administrator purely wants the result to be trusted as the correct result and free and fair access. Now, if that engenders additional steps being taken, if that's the view, then that needs to be manageable in the polling station or in postal voting, etc. We're at that point at the moment. We would still believe that the system is trusted. Is there enough evidence to show that it's being less trusted, I think, that would then engender that to come through?
And surely that diminution in trust is going to be gradual over time. So you're going to have to make a judgment at some time when you should step in, whereas isn't it better to try and make those adjustments at a time when there still is trust in the system before trust fades in the system?
Certainly, and I say from any administrator's aspect, it's not so much about the bigger picture of something like voter ID. It's more about what are the implications to the voter in the polling station. And one of the concerns I think that we have is that, assuming rolls out in 2022, it's at a parliamentary general election, will there be queues at stations? Will there be a disproportionate delay? Could be, couldn't be, because it's not been tested through in terms of that type of scale of turnout at the moment. All I think that we would always argue for the point that any change to electoral law should be tested to see what are their knock-on implications. If they are appropriate knock-on and can be dealt with, then it's the right way to go. If they're not, then we need to think again.
I mean, a lot of colleagues in the Council of Europe expressed surprise that the UK is still based on this system of trust. How often do you talk to the Venice Commission about changes to electoral law and the administration of elections?
We don't. We haven't. No.
Okay.
No. There'll be more the Electoral Commission, I think, would have those conversations rather than ourselves.
Yeah, well, that's quite proper. I thought that you might as well, because there are a lot of proposals, and the Council of Europe has just finished the report. I was the rapporteur on changes to electoral regulations that we're recommending across the 47 countries for the rules on referendum. And likewise, the Constitution Unit has done a piece of work here that I was part of on that. And I just wondered whether you engaged with that as pieces of work, and because I think you would probably have quite a lot to offer from the practical on the ground perspective.
Thank you for that. David Morris.
How serious is the risk of postal voting fraud under the current system, would you feel?
I think the risk is clearly there. Probably much greater risk of postal vote fraud than there is of fraud in the polling station, I would say. I think it's impossible to quantify the extent to which it actually happens, but clearly, even despite setting up the software that we have to detect fake signatures and all those things, it's not foolproof, I imagine. People can fake signatures, and there's no oversight of that when it's going on in people's homes, so it's a risk. Counterbalanced, I suppose, by the ability to allow people to vote who can't get to the polling station. So we take all precautions through the postal vote process and with our software to make it as tight as we possibly can, but it's a risk.
I think in terms of the application process, with the change that brought in after the Birmingham cases in 2007, the signature, date of birth need and the checks that Louise refers to has certainly tightened it up. So in terms of the actual administration, I think it's reasonably robust. However, any absentee ballot, as soon as it leaves the grasp of a returning officer, whoever fills that actual ballot paper in, we don't know. It comes back in an envelope sealed, and we were just checking the signature and date of birth. So it's very much about what's out of sight. We can't control in that way.
And do you think, I know what you were saying about software, and there's verification in certain counts. If postal votes go in on the day itself and they can't be verified, do you think they should be allowed, or is that up to the returning officer themselves?
Well, we do still verify them. So if you're ever at a count, you'll see a table over in the corner of people ploughing through the postal votes that have come in, either handed in at the polling stations or into the council offices that day. We bring our electronic scanner and we do verify them in the same way as we would do before the day of poll.
I know in my area of Lancaster there was, I think it was 1,314 votes put in on the actual day at the count itself. That's a lot of votes to scan.
Yeah.
A hell of a lot of votes to scan. I mean, I've been to these postal vote openings and do that over a period of a couple of hours. It takes a long time with a team doing it. So how can that be robustly tested if it's just been done with the scanner on the day at the count?
It's the same process. So any postal vote that arrives 1 minute after they've been delivered through the doors to anything that arrives at the polling station, and you're still dealing with 1 o'clock in the morning, 2 o'clock in the morning, it will be exactly the same process, has to be followed. There was a change in the law. When it was first brought in, only 20% of postal votes needed to be checked. It's now 100%. So everyone has to be checked. And, you know, I have to say that sometimes causes frustrations at counts which are going on overnight, because you're waiting for the postal votes to be verified, because it's the same level of scrutiny being done on the first one as it will be on the last one.
I can echo that as a returning officer. Haven't you finished doing those postal votes yet? We've been here for 2 hours.
So how do we know how large the risk of postal voting fraud is, and how should postal vote fraud be tackled?
I think the answer is we don't. We don't know what we don't know. So, as Peter says, the system's based on trust. We have to trust that most people do the right thing. We don't know how many people would be doing the wrong thing.
Yeah. And do you think campaigners should be banned from handling postal votes?
I think that's right. I think keeping the distinction between the administration of the process and the campaigning is important. So that's what we're here to do. If political agents want postal votes to be issued, they should contact us and let us do it.
And that's one of our recommendations and has been for a while. On the basis, simply, it comes down to transparency and trust. At the end of the day, making absolutely certain that that individuals can't be coerced into providing votes very easily in that sort of way. How that can be prescribed is quite difficult. Who can handle, who's a campaigner, who's not, very difficult to actually define in law. But ultimately, it needs that's a really straightforward, very transparent check to put in place to show to the public that everything has been done above board.
And is it normal procedure to tell someone if the postal vote has been rejected? And if so, how long does that normally take for that person to know about it?
And we're legally required to write to everybody after the poll to explain that their vote was rejected, and if so, why. I think it's
3 months.
3 months is it to
to
get
the
the.
poll.
And interestingly, the first time we had to do that, I imagined there'd be a whole tsunami of complaints, but nobody actually responded the first time we did it. And we're talking tens of people, it might be 70, 80, 90 people, and no one wrote back to say they're outraged.
I was one of them.
Oh, was it? Some people did it again the next year.
In one election a long time ago.
Can I just ask what may seem a slightly loaded question, but it really is a genuine inquiry. I mean, Tambridge is a very different place from, say, Tower Hamlets.
Yeah.
So, to what extent do you think the evidence we're hearing from you both today is a reflection of the real hotspots of concern, where, like Northern Ireland, was a hotspot of concern and was addressed in a different legislative framework? So talk to me about, I mean, the experience we had in Tower Hamlets and in other cities which I won't name, but where we know that there's been much more acute problems.
I think obviously the risk is far greater in places where there's been malfeasance reported previously. The regime needs to be the same, and I guess you need to make sure that you're training your elected administrators, your agents, much more closely and keenly to look out for risk factors. So huge numbers of late applications for postal votes, lots of postal votes coming from the same address, all coming in on the same day, or being handed in together at polling stations. All those things that might set alarm bells ringing. You need to be doubly sure that your administrators in those areas where there can be risk are aware of. Woking's had a similar situation in Surrey, so not very far away from me, and I think they've had a couple of petitions as well in the last few years, so they keep us up to date with what the risks are. So I agree, different parts of the country pose different risks, but the legislative framework needs to be the same. It's a question of having training for the people administering the system in the relevant places.
I think one of the positive effects of the issues in Tower Hamlets, which were very well documented as we know, was exactly as Louise mentions, in terms of it raised awareness that in the, forgive the terminology, the sleepier suburbs, where you wouldn't expect there to be quite the same issues, the risk factors have been identified. The keys to actually there's too many applications coming from one address, or there's too many names looking the same coming in this sort of, that are flagged up that electoral fraud can take place anywhere. In the areas where it's been well documented, there will be a lot of resource and time spent looking at that. But equally, the good practice that's come out of that has meant that in the areas where you wouldn't traditionally expect it, the same sorts of checks are being done through software systems and the like to make sure that, again, the public can trust the system.
Kelvin Hopkins?
It's just one problem that arose in the past, I understand, may not be so much now, was the care home managers would often fill in postal vote forms for residents, some of whom might suffer from dementia, for example, and that could be a source of fraud. In other areas, of course, you can find large numbers of postal votes handed in, all in the same hand and all with the same colour ink or whatever. There are ways of checking on these sort of problems. And I'm not suggesting that some of them are massive now, but they ought to be stopped if they happen.
They're exactly the sorts of things that are the red flags, effectively. So something doesn't look right, we need to investigate. And that could be either through internal investigation directly with a care home, for example, or equally if there was a perception that there was genuine fraud being perpetuated, that's when, again, the police are the ones who will be called in because they have got the expertise to do those sorts of things. So they're the sort of things that possibly may have gone under the radar in the past, but because of the very high profile across the UK in certain places, it has raised those sorts of things as standard practice to be aware of.
Thank you.
Alan Smith.
Hi.
Cracking on.
Thank you, Chair. Do you have concerns with other aspects of the absent voting, such as emergency proxies?
I don't particularly, but it's probably something that our administrative colleagues have to wrestle with more frequently.
And it is wrestle because of the lateness of the applications. Very sensibly brought in for, as things stand, medical emergency and for working away at last minute. And because it needs to be countersigned, it does mean it's the old system of absent voting, which means there is that level. When I say we've got any concerns about it, it's more the fact that it's quite a limited number of individuals can use that route. It can sometimes get very, very frustrating where somebody has been called away to care for an elderly relative, or there's been someone's passed away and they've got to go to another part of the country. They cannot register in that way. They're being denied their vote because of circumstances changing late in the day, whereas if you posted for work or you'd actually fallen ill yourself, you can. So the system itself works. It's whether it does everything it needs to do to allow access to those who genuinely need it in an emergency situation.
Colin Hopkins.
My question is to Peter Stanion specifically. Yep. Your evidence said that it is not possible to identify how many people have voted twice in a general election by voting in different areas, and that this is a concern that should be tackled. How should this issue be tackled?
This came about because of the parliamentary election, the last parliamentary election, the unscheduled, where there was a number of assertions on social media that might tend to be students who'd voted in two locations. How can it be checked? Well, each individual electoral register, each individual returning officer works independently, so there is no joined up method of doing so. It does beg the question whether there should be some degree of centralised register of voting or something like that, if it's perceived to be a real risk to the process. It goes to the residency issue that our colleagues in the Law Commission were talking about earlier. As things stand, you can register in more than one location. But the check isn't in place we're working on that trust system that someone's only voted once at a parliamentary election in the one location. The only way you can do that is to have that central register.
Well, it would suggest rather like personation. It's a minor problem really in terms of numbers, and it's really a question of voter confidence in the integrity of the election.
Absolutely.
So that's. But is it still really appropriate for people to able to register in a secondary residence, given that we now have postal voting, and the problem is not sufficiently serious to warrant a kind of major input of resource to deal with it?
I think we'd echo what the Law Commission, so I think it was Henny, in terms of the discussion probably needs to be had now because of the nature of why people are able to register twice. There is case law as to do with students, which reinforce that right. There are arguments pro it in terms of, well, I've got a tie to the local community, so therefore I shouldn't have a say in the way that that I'm represented both nationally and locally. Equally, somebody who's got more than one property therefore gets greater say over the people who govern them effectively. All that we'd ask for is the certainty. In terms of the bigger issues tend to be, and I was talking to a colleague only the other week with regards to, for example, holiday homes, where for 9 months of the year the park will be open, for 3 months of the year it's not. And there will be different views taken by different park owners as to whether they will allow people to register at the caravan. but because are they demonstrating residence? Now, residence, as we know, already has not been defined strictly. It's, do you consider that that person lives there? Now, you can argue 9 months of the year they do, 3 months a day. Is that enough to give them the right to vote in that particular local authority area? Some registration officers will say yes. Others will be leaning on the, well, no, they're not really living there. They're there for a shorter sort of period. So it's, the certainty as to those sorts of things is probably needed greater than the issue with regards to voting twice. Because it's about actually what rules can the registration officer work to say that, yes, I can legitimately say that person should be registered there. Should it be a default that they are, rather than it being left to the discretion of the registration officer? So there's lots of questions I'm sort of throwing back, because it's not an easy answer to get to the bottom of it.
But that, I would suggest, is rather small. They're small numbers, and the big question is about students, because we get thousands, tens, if not even 1 million or two students who. But individuals can choose where they register. If there was just one registration statement for statement of residence for their electoral purposes, and then they can get a postal vote, which solves the problem, I would suggest. Are we not really making too much about the need for having 2 residences and rights to vote in 2 different places? If we just got rid of that and people could choose, and even if they were politically involved, as I would choose to vote possibly in the one where the seat was more marginal. But even then, is the voters' right to choose.
I think you're absolutely right, but we'd still be working on the basis of trust in terms of the application that's being made to which of the authorities are you actually working to. Because without that central coordination of the fact I own 1, 2, 3, 4 properties, which one am I choosing? I think the Law Commission talked about demonstrating, even if you stay with 2 residences, but I'm going to cast my vote from this particular residence. That might be the sort of way forwards, but it ultimately comes down to trust, because there is not that national database of where everybody is actually residing.
How strong has the case been made that people should have just one electoral residence, if you like? Has that case been made, and has it made very strongly so that people could only have one place where they can register to vote, not more than one?
I think there is an argument to be made, a number of arguments to be made, as Peter said, but I think if apart from students, if people are paying council tax in 2 parts of the country, there's a reasonable argument they ought to be able to have a say in who stands for, or who's elected to the council for that part of the country. I think it's different in the parliamentary framework, because you wouldn't want people who happen to have more money and more houses to have perhaps more say on who comes to this house. So I think it's really one of those wicked questions, to be honest with you. But also, it's just the practicality, isn't it, of that no one's required to tell us they've got second residence, so we wouldn't know. If we did know, and people are registering, in my relatively small case of 67,000 people on the register every year, how much time is my 3 election staff going to have to be to put people through some test of how many days they live in one place or how they stay? So I'm not sure it's a problem that's so broken that we need to fix it, or prioritise fixing it anyway.
Just one register. Anyway, I've made my point. Thank you.
On that point where you were saying before about park homes, I mean, I have a lot of park homes in my area, and it's about how many, do you pay council tax on that park home? And they don't. But just saying about, do people pay council tax in 2 areas of the country? I know in my area of Lancaster we had, activists going around asking for any junk to be thrown away and to take it away, and after the white cards. We knew this went on. So, those students weren't paying council tax in that area. However, they were still entitled to a vote because the rolling registration wasn't updated in real time. Do you not feel there's an anomaly there? So, in the respect that the council tax isn't being paid by the students, it's not actually being paid by the park home either, but
that's what's a real problem. So students might be a different case from someone who just happens to have 2 houses.
Yeah. I think the crucial rule that registration officers have to abide by is the person resident, and residency has not been defined, other than the fact that there is the case law with the students in Exeter and Cambridge, which demonstrates they spend a significant proportion of their time, and that's the rule that we're still working to, and that case was back in the early 70s, I think, from memory. So that's the difficulty in terms of defining exactly that.
Okay, Rupa.
Yeah, in an age where we live more of our lives online as well as offline, isn't it time that the sort of imprint rules applied to digital material as well?
Yeah, I think we both agree that any political campaigning ought to be clearly identifiable to the candidate or the party who's involved. How that can be administered is a completely different ball game, and I'm not sure we're experts in how that could possibly be the case.
So I think that's right. If it's the parties, or the candidate's Facebook page or Twitter account, then I think an imprint on the landing page or the home page, it becomes more difficult for individual tweets and all those things. I think to have imprints on it, I think that would be virtually possible to administer and all police.
Yeah, I mean, we've all heard of Cambridge Analytica and the illegal data targeting, harvesting, Russian influence, all this stuff, bots, dark money. Don't you think also that it, as you mentioned, platforms should be more responsible? They seem completely unregulatable. How practical would it be to enforce rules on platforms, Twitter, Facebook, the lot?
About as practical as it is to enforce any other rules on them at the moment, I would say. I don't.
I mean, they don't turn up to these meetings when there's subpoena to, it's like the Wild West, isn't it?
Mm. I think it's probably, we'll plead the Sixth Amendment at this particular point, because that's an area that the Electoral Commission, the good news again for returning officers, as I said earlier, is that anything to do with that type of campaigning, the standard response is an Electoral Commission responsibility. And I know that they are very actively engaged in trying to work out what the right routes are for that sort of, for the management of that side of the process. It's hard.
Thank you. Dave Sherman.
The Constitution Unit, on its report on updating the rules on referendums, looked at this area, and we were very concerned, first of all, because there are very different restrictions on different media and advertising for different elections. How much of a problem do you think that is to the system?
In terms of?
Well, when you have different restrictions on media at the moment, and of course social media has now exploded, and really the rules that govern that are now completely outdated. Do you think that is a problem and needs looking into?
It's a problem that needs looking into, I would suggest, but I think it goes back to the very the root cause is that if you look at the Representation of the People Act 83, I think the words broadcasting are in there. I think it's very much based on what it was in 1872. Now, has the law kept a pace with change? It clearly hasn't, because the change moved so quickly more recently. Whether there's need to... I think it very much depends on the type of platform and whether it can be deemed that a political party or a candidate is getting a greater advantage over others. I mean, it's all about consistency of message to the electorate. That's the whole point behind this. So if somebody's got a Twitter feed, well, everybody can have a Twitter feed. But if somebody, such as one of the providers, is providing a greater access to landing pages, for example, that's, I would suggest, a slightly different story. But at the moment, it's not provided for within the electoral legislation.
One of the Constitution Unit's recommendations was to have a publicly available and searchable online repository of political advertising, for example, that wasn't just as simple as it sounds, but also included, when items were posted on electronic platforms, what groups they were targeted at, the level of the spend. Is that the sort of thing that you would support or think would be a good way forward?
Difficult to say, but
I think it's so complicated. I think the risk is everything's moved so quickly, doesn't it? So by the time we come up with a solution for this problem, the problem will be a completely different one. And I wonder whether at some point we have to strike that balance between not undue influence on elections and just accepting that's the way the world is now, and we can't clamp down on it and regulate it. It's just not possible. The cat's already out of the bag, as it were. But that's just a personal opinion. Not so we shouldn't try. But
because you're moving towards really having a standing committee looking at this all the time and constantly updating it, because that's possibly the only way that we will be able to keep pace with the technological changes, particularly over this last period of time.
I think much of it comes down to, I say, the public trust in elections, and from a returning officer's perspective, the election will be run according to law. And a lot of the debate that's going on extraneously is actually not directly influencing the actual delivery of the election in terms of the administration. It's to do with the engagement with the electorate, and that then becomes something outside the remit of a returning officer in terms of taking that
Because
forward.
what Dr. Huck was referring to is definitely undermining the trust and the confidence in elections, and therefore it needs to be addressed, and it can only be addressed by institutions like this one that we're sitting in at the moment, and constantly monitoring it, presumably. Any other ideas on that?
You've exhausted them.
Ban social media.
Well, there's a really good idea.
Anyway, thank you very, very much for your time and for the care you've given answering these questions. It's been very interesting and informative from our point of view. And if you have any other further comments that you want to contribute to our report, do send them in. We'd be very grateful to have them.
Thank you very much.
Order.
Thank you.
The proceeding has ended. The proceeding has ended.